Okay, so good morning. Thank you for joining us for our webinar, Cost Savings for Business webinar. My name is Matthew. I am the employment solicitor at Optimal Solicitors, and I've been with Optimal for the last 3.5 years. And today I'm joined by Naomi.
Good morning. I am a solicitor and I work across the civil and commercial teams at Optimal Solicitors. Prior to working for Optimal, I worked primarily as a freelance solicitor, mainly advising on a broad range of issues such as employment, commercial and civil work.
Yeah, brilliant. So just a bit of housekeeping for today's webinar. Whilst we appreciate comments and questions, we request that all questions are directed into the chat box, and me and my colleague will try and pick some up to answer. If we could request that all microphones are muted during the webinar, that would also be appreciated.
Yeah, if there are any questions that we're unable to get through in today's webinar, we'll be happy to provide further information at a later date.
Yes, brilliant. So today's main focus will be on ways that a business can reduce costs in the current economic climate, and we will be currently focusing on this primarily from an employment perspective.
Most employers will think of redundancies as the principal way forward when it comes to cost saving. However, there are other factors that can be considered.
Yeah, so we'll be covering quite a few topics today: contracts of employment, workplace policies and practices, alternatives to redundancy, the actual redundancy process, and settlement agreements.
Once a business becomes aware of possible financial difficulties, they should try to take proactive steps to resolve those difficulties. It's all too easy to try and ignore the situation and hope that the matter resolves itself. However, seeking legal advice at an early stage can prolong the financial viability of the company in the long run.
Yeah, I think that's great advice. I know from having these conversations with clients, they will obviously try to bury their head in the sand, which then becomes detrimental to themselves and the business.
Definitely. Talking the matter through, especially with a legal advisor, can often take the weight off their shoulders.
Yes, I agree. So, Naomi, when would you conclude that a business has long-term financial difficulties and needs to start taking legal advice?
Obviously, this is down to the individual businesses and business owners, but I think, if they're becoming concerned about covering overheads, such as wages in particular, then they really need to be looking to get advice urgently.
Yeah, thank you for your insight. Turning to matters today, let's firstly discuss the contract of employment.
Yeah, the first point to note with a contract of employment is that it is a legal requirement to provide employees with a contract from day one of employment. While some businesses feel that contracts of employment are unnecessary, in reality, a well-drafted contract of employment will assist a business in times of financial difficulties.
Yeah, so not only should the contract of employment be provided, they should be regularly updated. I've come across contracts that are 10, 15 years old that are simply not fit for purpose. So in your experience, Naomi, how often would you advise a business to review and update their contract of employment?
Well, employment is an ever-changing area of law, so much like many other contracts, I think all contracts of employment and contracts relating to employees should be reviewed annually to ensure that they comply with both legislation and company need.
Brilliant. So in bringing this back to our cost savings today, so what clauses in the contract of employment can assist a business that is in financial difficulties?
There's a couple of clauses in particular in the contract of employment that are important here. Firstly, in the contract, is there a flexibility clause allowing the business to reduce hours in the event of a downturn in work? Also, is there a clause in the contract that allows temporary layoffs? Could the business request that employees use up their annual leave during a decline in work? All these things could be considered.
So how best would you utilize these clauses, as obviously these sorts of clauses being enforced against the employees could lead to some form of resistance?
Well, I think in all circumstances, consultation is fundamental. The business should always consult any union representatives as early as possible, and they should try to provide a time frame for how long these clauses may be enforced, if this is at all possible.
And if there is no union to consult, we would advise consulting directly with the employees. The business could allow the employees to elect representatives. That way, this can streamline the process of consulting with the employees.
Exactly. The business should be as open as possible. Whilst there's likely to be some resistance, it may only be a temporary measure to avoid the business having to go through a redundancy process. Most employees would wish to avoid redundancy, so they'd want to know what's going on.
Yes, in your expertise, is there anything that the business should be also considering at this stage?
Businesses could look at their workplace policies and procedures, and that's always good to review those.
Yes, I suppose this is similar to sort of the contracts of employment that we mentioned earlier. Workplace policies should also be regularly reviewed and updated, especially as it's often easier to update a workplace policy, as these will usually be non-contractual.
This is true. What workplace policies do you think would assist most for a business that's in financial difficulties?
So similar again to the contracts of employment, the business should have a clear annual leave policy. In the policy, the business should be allowed to request that employees use up annual leave when the business required, especially in periods where the business is quiet, and then also preventing employees from using annual leave during peak times, which you'll often see is the run up to Christmas.
Yes, another useful policy could be one that relates to overtime and bonus payments. A business shouldn't be obliged to provide overtime or bonuses if they're in financial difficulty, and having such a policy can prevent disputes arising.
Yeah, at this stage, if the business has implemented these recommendations in relation to the contract and the workplace policies, however, they continue to remain in financial difficulties, is that when you would suggest the business starts considering redundancy?
Yes, they could do, but before the business commences the redundancy process, they can consider other alternatives to redundancy.
In your expertise, what are the main alternatives to redundancy?
A business could reduce or stop any recruitment before commencing a redundancy process. In fact, they should do this really as soon as possible. There are significant costs involved in recruitment, and stopping this even for a few months can have a positive impact on the business financial position. From practice, I think as well that if the business restructures, this can prevent redundancies and is often a more favourable method.
I suppose this leads back to our earlier point on contracts and also the workplace policies. Having flexibility clauses in relation to hours is fundamental, but also having some degree of flexibility in the employee's job role is also important.
Yes, absolutely. Wording such as your position and duties are X, but if the business requires you may be asked to undertake other suitable roles, will help the business implement a restructure quickly and effectively.
Again, the business should be consulting through this process as well, ensuring that the employees are fully aware that the reasons that these options are being explored is really to prevent a redundancy situation arising.
Yeah. But at this stage, if the company's position still appears to be in financial difficulty, then before going through the formal redundancy process, is it worth exploring voluntary redundancies? How would you approach this?
So this depends on the size of the business and the amount of redundancies required. However, if the business believes that they only need to make 2 or 3 redundancies, then it may be worth offering an enhanced voluntary redundancy package.
Would you suggest that that's done by way of a settlement agreement?
Yes, definitely. Settlement agreements would certainly be advantageous to the business.
In basic terms, what is a settlement agreement?
So this is a legally binding contract between the business and the employee, which will prevent the employee from pursuing legal action against the business in return for compensation. In this scenario, the settlement agreement would be used to terminate the employment relationship by way of redundancy, and the employee would then receive compensation for this. So it would be their redundancy pay, maybe a couple of weeks on top of that. And then the business would have peace of mind knowing that the employee could then not pursue a claim for basically arising from the redundancy dismissal.
So the employee would probably need to get legal advice for that. Would the business be prepared to cover their legal fees for doing that? If they're in financial difficulty, would they not be trying to save costs and get out of that?
Yeah, I understand that perspective, but let's look at sort of a bit of a background into it. So the legal fees that you offer for a settlement agreement range from about £250 to £500 plus VAT. In return for the business, they have security and peace of mind knowing that the employee cannot pursue them in the employment tribunal, for example, for an unfair dismissal claim arising from the redundancy. The average cost to defend a tribunal claim from the last data taken, I think it said it was around about £8,500. I believe this is now a few years old, so I would state that the figures would probably exceed £10,000. So obviously, as we're talking about cost savings for business, the last thing that the business is going to want to do is to be spending significant costs defending a unfair dismissal claim, when they could just pay for the settlement, the legal fees for the settlement agreement. There's also other factors to take into account. So there's a lot of time involved for the business, searching for all relevant evidence. So this would probably include the IT team having to do searches of the database. Also, HR will probably need to be involved. This is a considerable amount of time preparing for a tribunal hearing. The legal representatives, solicitor and barristers, they cannot operate in a vacuum. They need detailed instructions from the business. This also would include the managers, HR. There's also a possibility that if the claim went to final hearing, this could be over a few days. So you mean, again, managers, HR taking time off. Finally, is one of the big factors as well is the stress involved in a tribunal claim. This is often overlooked. However, the toll on the business owners, HR managers can be significantly detrimental. Claims take well over a year to reach final hearing, depending on which tribunal is hearing the claim. So if you look at that in perspective, it's a few £100s of legal fees. It's well worth the outlay when you consider what this could prevent in the long run.
Yeah, definitely. So once the business has explored the voluntary redundancy process, but still requires to undertake compulsory redundancy, what would the next steps be?
Firstly, I think it's useful to look at the sort of meaning of redundancy. So redundancy is where an employee is dismissed due to the intention or the intention to cease business for which the employee was originally employed. Redundancy can also be caused by a business closing down premises where the employee was originally employed.
So looking at this wording, redundancy only applies to employees, so agency workers and subcontractors wouldn't be entitled to any form of redundancy pay.
Yes, that is correct. So this is one of the primary advantages of engaging exchange agency workers and self-employed individuals, as long as they are genuinely self-employed. There are many occasions, I'm sure you are aware, where an employee is engaged as self-employed, but when they are in fact actually an employee. I will not go into this in sort of further detail because obviously it's quite a complex area. But if a self-employed individual can demonstrate that they were in fact an employee, then they could then actually be entitled to redundancy pay.
Okay, so when will an employee qualify for statutory redundancy pay?
Yeah, so leading on from that earlier point, they would need to demonstrate that they were an employee and have accrued at least 2 years continual service.
Okay, we mentioned earlier about consultation. When would a business be required to consult?
So there is a legal obligation on a business to go through a consultation when 20 or more employees are made redundant. However, even if there is no legal obligation to carry out a consultation, I would strongly advise that a business carries out the consultation process. As mentioned above, we've talked about it a few times, the business should be consulting with any union or elected employee representatives throughout this, just to keep the employees updated. In your experience, what are the primary factors when you're looking at a consultation period?
Well, there's a few points that the consultation should focus on. One of the key elements would be to explore any suitable alternative employment for employees at risk. Business should really try to avoid dismissing an employee due to redundancy if there is a suitable alternative employment available.
So is this where most of the challenges come from when there is a challenge to sort of the redundancy?
Yeah, from my experience, most employees will challenge redundancy based on two main areas, either the failure to explore suitable alternative employment, but also where they feel that an unreasonable method of selection has arisen.
I do believe that many businesses overcomplicate the method of selection, when in practice, a very simple process will often be sufficient. The test applied by the tribunal is whether the selection was one that a reasonable employer acting reasonably could have made. This is a very generous test from the tribunals, which simply requires the business to act reasonably in the selection method.
So once the employees have, sorry, I just got distracted then for a second. Once the employees have been made redundant, does the business need to allow for the employees to appeal?
So redundancy dismissals are different to the sort of ordinary dismissals that you see. So there is actually no obligation to allow for an appeal, whereas with other dismissals, such as your misconduct or capability dismissals, there is an obligation to allow for an appeals process.
Okay, so and then would it still be advisable to go through settlement agreements with the candidates who were made redundant?
Yes, as I stated before, I think the settlement agreement is the best way to operate, especially for the business. Obviously, as long as they can afford to pay the legal fees, it's definitely worth going down that route.
Yeah, I think that's a really good advice. Thank you, Matthew. I think this session has been really helpful. I apologise for getting distracted a little while ago, but we've had a couple of questions come in. So if I can read through these, can you give them some thought?
Yes, yeah, I'll be happy to.
Okay, first question that we've had is how long does the redundancy process usually take?
Yeah, so this depends on the number of redundancies. If there are less than 20 employees being dismissed, there is no specific timeline for the redundancy process. But if there are 20 or more employees being made redundant, consultation should be at least 30 days. Again, I would even say, though, even if you're dismissing less than 20 employees, I would advise the consultation process at least takes a few weeks. So even if it is less than the sort of obligation to go for 30 days, I would say, you need to show to the employees that you're fully exploring everything. A further point to note as well, if it is a large scale redundancy, so you're talking 100 people, sorry, 100 employees or more, you should again be looking at that. It should take at least 45 days. However, in practice, I've done a few of these, and actually the redundancy process takes several months, so it can be a very long-winded process when it's large scale redundancies.
So companies and businesses really need to be keeping an eye on where things are, and if they think redundancies are going to be likely, they need to start thinking ahead of time about doing that.
Yeah, definitely.
Okay, kind of following on from that, another question that's come through is, what happens where the company's financial position is such that they can't actually afford to pay the redundancy payments that that employees are entitled to?
Yeah, so unfortunately, this is not an uncommon scenario. If the company is unable to pay the redundancy, the employees affected should commence a group action claim against the company. This is primarily to protect their position. So this would be going through the conciliation process through ACAS. If in the meantime the company enters into insolvency proceedings, because obviously they can't afford to pay their overheads, then an insolvency practitioner would usually be appointed. They will write to the employees, giving them a case number, which is obviously sometimes just called the CN number, which then allows the employees to go onto the government website to receive their payments. So the redundancy payment is paid from the National Insurance Fund. So as well as the redundancy pay, they could also seek any unpaid wages or unpaid holiday pay as well. So they could be all entitled to that, and that comes from the National Insurance Fund, not the company. So at least they know they have a little bit of protection there.
Well, that's interesting. Thank you very much, Matthew. I think that's been really helpful. And if there are no further questions, then I think we'll say thank you very much for joining us.
Yes, I would also just like to say thank you for everyone for joining us today. Again, like we say, if you have any further questions, please do not hesitate to contact us. We will be happy to assist you further if you require. Thanks very much. Bye now.
Thank you. Bye-bye.